with Phoenix Life Transitions. And today I'm going to be interviewing attorney Nora Jones. Very excited to have her. And in the past, Nora, as you know, we have interviewed other estate planning attorneys. Libby Banks, who's terrific. I love her. She deals almost exclusively with those cases which are not litigious. And you're kind of on the other end of that spectrum. You specialize in those situations where an estate is going through a trust or a probate process, and the family is fighting. And so tell us a little bit about that. How did you choose that particular niche of the law?
Well, first, thank you for having me on today. It's really great to get a chance to speak to you about this. And I can say with full confidence that the area of law that I do is just something that I love. And I really don't think that I could do basically anything else at this point. I think I'm pretty pot committed to this area and just practicing law in general in this area. So I got into this really in many ways by accident. I had an interest in helping disabled and vulnerable people, and that's part of what drew me to go to law school in general. Was the idea of being able to be an advocate or a voice to those individuals. But I didn't know what that meant or what that could look like. And so when I started practicing law, I just got a little taste of some of this area. And I was so intrigued by the direct impact I could make on people's lives just by advocating for them in these trust and estate litigation matters. So pretty early on, within just a few months of starting practicing, my practice began to focus exclusively on this. And now I do specialize. I'm recognized by the State Bar of Arizona as a specialist in trust and estate litigation. But what I have loved about it is that my practice requires a lot of counseling. And it's one of the things that I like to do the most is to be able to counsel people and work through really difficult situations that they're in and provide them a lot of compassion and a voice and legal advice, but also some non-legal advice, which is often as important as the legal advice.
Mm-hmm.
So that's what I've loved about it, is that ability to counsel and help people work through what often are decades-long family issues that have now come to a head in some kind of litigation regarding a trust or estate.
Right. Also, one of the points that Libby makes in our conversation earlier is that a lot of these fights can be avoided by having a good trust document or good estate plan laid out. But you tell me in our earlier conversation that that's not always the case, that sometimes even well thought through plans end up in litigation. Tell me a little bit about that. How does that happen when people take a lot of time and try to think through what they need to do not to have that? What's the situation?
Well, I agree with Libby in the sense that the most important first step you can take to protect yourself from being in a situation where your family is in estate or trust litigation after you pass away is to have an estate and trust, to create a will, to create a trust, to plan ahead for what is inevitable for all of us.
Right.
And so that is really critical. But there is no such thing as an ironclad estate plan or a will or a trust that will prevent litigation from occurring at all. Unfortunately, all it takes to have a trust or a will be litigated is a will or a trust and an unhappy person with what that will or trust says for them. So there's really no way to prevent something from being filed. Now, there are things that we can do that can prevent a will or trust contest from being successful, but filing a lawsuit and ultimately costing the family a lot of money, even with a lawsuit that has no merit at all, can be extremely expensive.
Mhm.
But there are things that we can do with estate planning that can make the chances of somebody being successful at trial with trust litigation. There are some things we can put into the documents that help with that.
Okay. Now, there are different types of litigation, are there not? Like there's a if there's a will, then it might be the will might be contested. That would be one approach, right? Or if there's a trust and there's a fight, what kinds of fights can people have about a trust?
So there's a handful of causes of action that in anytime I'm approached by somebody saying that they think that the estate plan that's been created is not fair to them or does not provide what they understood the wishes of their parents or whatever other loved one it may exist who passed away, there we look at whether or not the trust or will was the product of undue influence, which is where somebody has exerted so much influence over the individual who's creating the estate plan that their wishes and desires for their estate plan are overcome by the influence that the other person is exerting on them, to the point that the document does not reflect their wishes but the wishes of the influencer. So that's one of the most common things that we see. Those are the causes of action that are most likely going to be asserted as undue influence. There are other things like lack of capacity, but capacity is an extremely low standard. To have capacity to execute a will or a trust is just about the lowest standard you could possibly have and still be walking around in the world. So even people that don't have capacity to do a lot of things like drive a car or make important financial or medical decisions for themselves might still be able to execute an estate plan. So lack of capacity, while a lot of people think that, okay, well, grandma was pretty far gone when she signed these documents. If she has just the minimal capacity, then the court isn't going to set aside the document for lack of capacity. We also see things like fraud, where maybe a page in a document was switched out, or forgery, where the signature isn't the signature of the person.
Wow.
But the most common things we're seeing are undue influence, where somebody's being influenced to change their estate plan for the benefit of the influencer and not what the person who's creating the estate plan wants.
Okay. Yeah. One of the customers that I was dealing with in my real estate business told me about a situation where there was a family member who was an attorney, and they wrote up the trust document and they named themselves the trustee, and they added a lot of verbiage in the trust document to say that it's going to be done this way unless the trustee decides that something else is more equitable for the family as a whole, kind of thing. And it ends up putting that person really making all the decisions and not the person making the trust.
Yeah, and that's a whole other host of litigation that we'll see with estates and trusts, and that relates to the breach of fiduciary duty by a fiduciary like a trustee or a personal representative. And when you're serving in that kind of capacity, you are held to an extremely high standard to put your own self-interest aside and only look at benefiting the beneficiaries as a whole, not engaging in self-dealing, those sorts of things. So first off, attorneys are the worst. So the fact that an attorney was serving as the trustee and creating the will, I'm not surprised you were headed to trouble there. But what we really see a lot is people that are abusing their positions of power by benefiting themselves to the detriment of others when they're acting as a trustee or personal representative.
Okay. So let's talk about cases, because I know one of the things that is most um, helpful to individuals like myself who want to get an estate plan, wanted to put together something like that, is they want Um, they want to know something about what can go right or what can go wrong. And I would love to hear some cases from you that you think our audience would benefit from.
Well, the only cases I see are where things do go wrong. Unfortunately, I never get to see the good part, and so it skews my perspective so often when talking to people, because we can forget that many, if not the vast majority of trusts and wills are administered without any kind of problem whatsoever. But when I see them, it's almost certainly because something weird has happened. And what's fascinating to me about this is that while the stories that we hear are so egregious and so troubling, they almost always follow an extremely similar fact pattern. So the most of the times when we're looking at trust or will contests, we're seeing um, a child that influenced a parent to benefit themselves to the detriment of other siblings, um, and 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 sometimes we're seeing where a third party, like a girlfriend, after maybe an elderly man has his wife has passed away, all of a sudden a girlfriend comes into the picture, and very quickly she has positioned herself to where she's receiving a large portion of his estate. So the stories that are the ones that stick with me the most, or haunt me the most, are and one comes to mind where the action of taking advantage, this individual, doesn't start with the estate plan. It often starts long before. And so what we'll see, and in this particular case I have in mind, is we see somebody quickly come into this man's life and start receiving little gifts of amounts of money, small denominations, $100, $500 at a time, transactions occurring. And then very quickly, once she gets comfortable that's going to work, that's working, they're getting those payments. We saw the amounts go way up to tens of thousands of dollars being pulled out of, at this point, the decedent's bank account. And when we found it was after the decedent passed away, because generally these things are done in complete secrecy. And so the family members, they might have a suspicion that something is happening, but they don't have an ability to do anything because they aren't able to get into the bank account or stop those transactions occurring until they know for sure that they're occurring. So that is one fact pattern I've seen, but it's a fact pattern, unfortunately, I see all the time. And what that bleeds into is that while we're often doing probate and trust litigation, which includes will contests or breach of fiduciary duty claims, we also are seeing an unfortunate high level of financial exploitation, particularly in Arizona. We see a lot of cases where vulnerable adults are being taken advantage of and exploited by somebody that is in a position of trust and confidence, somebody they should have been able to trust to treat them fairly, and takes advantage of them at their most vulnerable.
And who are these people? Are they neighbors? Are they family members? Are they boyfriend, girlfriend? How is this happening?
They're the closest people to them is the simplest answer, because it's not just someone off the street, unless that someone off the street becomes extremely close to them extremely quickly. It's almost always children or grandchildren or significant others that have come into the individual's life. Sometimes we'll see friends, sometimes neighbors, but it's almost always the person closest to that elderly individual. And that's in part because when people are aging, if they're aging alone, which is very common, they are desperate for an opportunity to have companionship, have somebody care about them and take an interest in them. And then that just one thing leads to another, and they're being exploited at that point.
Yeah. So let's talk about how to avoid that. Are there some yellow flags, red flags, that kind of thing? How do we avoid having the elders in our lives that we love be exploited?
Well, for exploitation, what I tell people is keep a dialogue with your loved ones. Make it a safe space for them to talk about things with you,
Hmm.
and and be on the lookout for signs that somebody is beginning to isolate, or that they're withdrawing from individuals that they've previously had a lot of contact with. um, Gifts being made, those are things that we become troubled by. Often people will say, she just bought a house and I don't know how she could have possibly afforded that down payment on that house. And it's because something like this is going on where someone is being exploited.
Okay. Now, we also, in our earlier conversation, we talked about the fact that oftentimes litigation kind of grows out of a family member who has been disinherited. Talk to us a little bit about that.
Well, that's the majority of my practice, is those cases where somebody has been disinherited. And it does often grow out of long existing family issues, because what generally is happening is somebody is contesting a will or a trust where they have been disinherited. So they expected to receive a portion of their parents' or grandparents' estate, and their parent passes away and they find out they're getting nothing. And to get to the point in a family relationship where a mom and dad say, I don't want my child to have anything, that is not a decision that any parent ever takes lightly. And so we are often seeing, unfortunately, dysfunctional families that have had issues that sort of people said, you know what, I always thought it might come to something like this. People are rarely surprised when they find out that they've been excluded from the estate plan, or that somebody maybe took advantage of their mom or dad, one of their siblings took advantage to position themselves to have a greater percentage of the estate. um, it's always shocking because it's very disturbing when it happens, but it's rarely um, a surprise when people think critically about what their family dynamics have been like. Now, that doesn't mean it's right. That doesn't mean that somebody was rightfully disinherited. And I will tell you, I think parents are well within their rights to disinherit anybody that they want. They don't have to give their children a cent. That money is their money to do with what they want. But the cases that I see are generally where it's not a surprise that something has happened because there's been issues in the family all along. And what that means is that these pieces of litigation are often deeply emotional, are not tied as much to finances, although often people were thinking or relying, unfortunately, on receiving a certain amount of money when mom and dad passed away, and now they find out they're not going to get that. But I have one case in particular that I felt like so highlighted how directly related to family dynamics this is, when my client was disinherited from her father's will. And there was some discussion before dad passed away between her and her sister about that this might be happening, that dad may have been influenced to cut her out of the estate plan improperly. And my client was saying to her sister in a recording, this isn't fair. You know, this isn't what dad really wants. You need to make this right. And she said, but that won't make you love me anymore. And it was
Wow.
like, wow. I mean, she just so earnestly said what is often underlying this is those kinds of family dynamics.
Wow. Wow. Okay. So, what advice do you have for people who are in a situation where they're thinking of disinheriting somebody, or they have disinherited somebody, and they want to avoid their family being caught up in this long-term litigation situation? What advice can you give them?
Well, like I said, there's no bulletproof estate planning document you can have because anyone can file litigation. It may be frivolous litigation, but anyone can file litigation. But the number one estate planning tool we have is what we call a no contest clause or an in terrorem clause. And
Mhm.
that's a clause that is written into a document that says if anybody contests this document, and they're entitled to receive something under it. By contesting it, they will receive nothing under the document and will be treated as if they had predeceased me. These are very powerful tools that in some states, the court system is less likely to honor those no contest clauses because they can be so harsh. But Arizona does enforce very strongly no contest clauses to disinherit people and set aside portions of an estate somebody was entitled to receive otherwise, merely by bringing a contest against the trust. Now, what I often have to have a conversation with clients about is what is a trust contest, because a trust contest is not asking questions of a trustee. You're allowed to ask questions of a trustee.
Right.
A trust contest is saying that you don't think that the document that's been presented as the estate plan should be the estate plan. So it's contesting the actual document, that the person was unduly influenced, or it was fraud, or they lack capacity. Those are the sorts of things that a no contest clause covers. Now, why those no contest clauses are so powerful is because even if you would be successful in setting aside that document, the no contest clause can be enforced to cut you out. You can have a good faith basis to bring a claim, but unless you have probable cause at the time you assert the no contest or the contest to the trust, you will be cut out from the estate plan as a whole. So the court doesn't care if once you start the litigation, you learn some really juicy piece of information that you say, it totally was a fraudulent trust. The court says you didn't know that with probable cause at the time that you filed, and so you will receive nothing.
Wow. Wow, that's interesting.
It is, and it can be so broadly written that it goes beyond the actual trust documents. It can be any inheritance that somebody would receive. So it could be under a trust, a will, a non-probate transfer. So if somebody had a brokerage account and they name somebody as a beneficiary on that, if they bring a trust contest, it could, depending on the breadth of the no contest clause, prevent them from receiving anything from that person's passing.
Wow. Wow, that's really surprising. Okay, I thought
You
that
know what who it's most surprising for? When people bring these claims without a good faith basis and they and they
yeah,
lose and they've lost everything.
yeah, yeah. So I've got another question for you. Have you ever taken a case and then after you took this person on as a client, were sorry that you did so?
So I'm very fortunate in my practice to have the benefit of being choosy with clients, because we do have a lot of opportunities for work. And it's very important to me that any case that I take is a case I believe in. And I do not, as a practice, take on any case that I don't truly believe is a meritorious case. And so that really vets out the ability to represent the bad guy or be on the wrong side of a case, um, because we get choosy on the front end of it so that we're not in that position very often. But there have been times where I've learned information as the matter has proceeded that I've said, "Oh, you know what? Now with this new information, I'm not so sure anymore that we're representing the good guy." And again, because I only represent people I believe in, when that happens, I stop representing that individual. And
Okay.
that's really important to me because the attorneys that practice in this area, it's a very small group. And
Mhm.
I can then say, when I'm dealing with an attorney that I've worked with before, look, I'm telling you, you guys, we got a problem here because I wouldn't be here if I didn't truly believe it. And it gives me a lot of authority to speak on it because I really can't do this work if I don't believe in what I'm doing.
That's a great answer. Thank you for sharing that. Now, before we go, I just wonder: is there anything else that is you think would be really valuable to our audience to know about? Is there a story or something that I should ask you and I'm not thinking to ask you?
Well, I think that one of the most important things in this area in particular to know about is that the timelines to bring these claims can be very short. And
Okay.
they can be shortened with some magic language in some cases that can limit your rights down to as little as 4 months in some circumstances after someone's passed away. And so, if you have a question, people should talk to an attorney because you might lose your chance. And at least to just talk to somebody and know if you have anything there or not. And a good attorney is going to tell you if you shouldn't pursue it. And like I said, I'm sort of choosy, so I turn down more work than I actually take on. But you should at least know what your options are. And so often in my line of work, people aren't looking for a payday with what they're doing here. They're looking for answers. They're looking for closure. And there are a lot of things that we can do to get those answers and get that closure without necessarily going down the path that people think they have to take.
Okay. Very good. I did think of one other question I want to ask you. So we were talking about contesting the trust, and that means really contesting the document. But
Mhm.
but there is a related situation that can arise, and that is if a family member just doesn't trust that the trustee is abiding by the trust document. What are their options in a case like that? What should they do?
Well, it's not unusual to have questions about if you're being treated fairly. And in probate court, which is where we have trust contests and will contests, the court really operates on the basis of notice. So if people know and have an opportunity to protect their interests and they don't do it, the court's going to say, hey, you had a chance and you chose not to, and you knew what was happening and you didn't do anything. So the because of that, it's really important that people spend a lot of time asking the right questions and getting the answers that they need. And trustees and personal representatives, like I said before, they're held to this very high standard. And one of the parts of that standard is that they're required to answer your questions. So if you're asking questions, they have to give you the answers. Now, that doesn't mean they always do. And that's when you maybe have to talk to an attorney, because if you're not getting the full answer, you need to be following up on that. If they're not communicating with you and they're not telling you everything, or you have questions about the information they're giving you, then that should be the sniff test of, okay, why wouldn't they tell me? Why wouldn't they answer this? Why wouldn't they tell me what's going on? And there's a special tool that we have in probate matters that really works more in trust contests or before an estate is open, and it's called a special administrator. And clients can be appointed as a special administrator where they are and they have the backing and power of the court behind them to ask questions, and the individual has to answer them. And financial institutions have to answer them. And if they don't, they can be pulled into court and held in contempt for failing to answer a special administrator's questions. So it's a really powerful tool that we use a lot when there are questions that need to be asked and we're not sure we're going to get the full answer or any answer at all. And that's often a first step. It's I call them a court-appointed investigator when you're the special administrator, but you're empowered by the court to ask the questions that you need to ask and get the answers you're entitled to have through that process.
Okay. Well, thank you so much. That's really been helpful. And, I know you also practice in another area related to this in regards to conservatorships and guardianships. We may want to have you back on at a future date to talk about those kind of cases, because we really appreciate you and everything you have to share for our community here. So thank you so much.
Thank you so much.